There is a signature on a legal document securing $430,000 against my home. It has my name on it. It is not my handwriting. There is a notary seal beside that signature. An official stamp certifying that I was present. That my identity was verified. That I signed willingly. On the date that seal was issued, I was 3 states away at my granddaughter's school event. There are photographs. A signed guest register. Witnesses. For 7 years, I believed my oldest daughter was helping me manage my mail. She was. Just not in the way I understood. When a foreclosure notice appeared on my front door for a mortgage I had paid off years ago, I did what I have always done. I went to my filing cabinet. What I did not find there was more important than anything I did. And that is where this story begins. I have lived in this house for 43 years. I know every creak in the hallway floor. I know which drawer sticks in the kitchen. I know the exact sound the front door makes when the afternoon wind catches it. So when I stepped outside on an ordinary Tuesday morning and found a document taped to that door, I noticed it immediately. A bright orange envelope. Official formal, addressed to me by name. I peeled it off carefully the way I do with everything. I never tear documents. My late husband used to joke that I treated every piece of paper like it might be needed in court someday. He was not wrong. I stood on the porch and read the document twice. It was a foreclosure notice. I want to be precise about what I felt in that moment because it was not panic. It was not fear. It was something quieter and far more unsettling. It was confusion. Because the mortgage on this house had been paid off years ago. Completely. We had the documentation. We had celebrated the final payment. I had kept the confirmation letter in a folder labeled exactly what it was. There was no loan on this property. There was nothing to foreclose on. I assumed it was a clerical error. Some misrouted notice intended for a different address. These things happen with large institutions. Numbers get transposed. Names get confused. I brought the notice inside and set it on the kitchen table. That was when I called Karen. Karen is my oldest daughter. 47 years old. She has lived 15 minutes from me for the better part of a decade. And for the last 7 years, she has been the person I relied on for anything that felt administratively complicated. She answered on the second ring. I described the notice. I read her the reference numbers. I told her it was almost certainly a mistake, but I wanted to know what she thought. She responded before I had fully finished the sentence. Mom, that is just bureaucratic nonsense. Those notices go to the wrong address all the time. Don't worry about it. I'll make some calls and get it sorted out. I wrote down what she said. Not because I was suspicious. I wrote things down out of habit. But when I looked at those words on the notepad later that afternoon, something about them felt slightly off. She had answered too quickly. Not too quickly for someone reassuring a worried mother. Too quickly for someone who had just heard the information for the first time. The explanation was ready before the question was finished. I told myself I was being overly analytical. Karen was efficient. She was organized. She handled things. That was who she was. That was who she had always been described as, anyway. I spent the rest of the morning doing what I do when something doesn't sit right. I went to my filing cabinet. It is a 2-drawer metal cabinet in the small office off the hallway. I have kept records in that cabinet since before my children were born. Property documents. Insurance policies. Tax records. Bank statements. Receipts for major expenses. I pulled open the top drawer and began looking for property correspondence. Current year property tax notice. Nothing. Prior year. Nothing. I moved to the second drawer. Mortgage confirmation. Old records. The paid-off letter exactly where it belonged. But recent correspondence. Not one notice. Not one tax statement. Not one letter from any county office or financial institution regarding this property. I stood in that small room for a long moment. 7 years of property ownership generates a considerable amount of paper. Annual tax notices, occasional county assessments, insurance renewals, utility correspondence, periodic statements from various institutions. A house does not go silent for years. Not unless someone is making it silent. I thought about the mailbox arrangement. The agreement Karen had suggested 7 years ago, when she said she would help me manage my correspondence so I wouldn't miss anything important. I had thought of it as a convenience. Standing in front of that filing cabinet with empty hands, I began thinking of it as something else. I pulled out every folder in the top drawer. I checked behind them. I went through the second drawer completely. I found nothing from the past several years that should have been there. Not one tax notice. Not one warning letter. Not one statement. And that was impossible. I did not sleep well that night. Not because I was frightened, but as I was thinking. When something doesn't add up, my mind doesn't rest until I understand why. It never has. By morning I had made a decision. I was going to build a timeline. I pulled every folder from both drawers and carried them to the kitchen table. I made a pot of coffee I barely touched. Then I began sorting by year, working backward, laying documents in rows across the table the way I used to organize school records when I was still working. What I found in the early years looked normal. Bank statements, insurance documents, tax notices. Everything arrived in order. Then gradually the rows began thinning. I want to describe this carefully because the pattern did not announce itself. It crept in. Year 1 of the mailbox arrangement, my records looked complete. Year 2 mostly complete. Year 3 I noticed the first gaps. A bank I had held an account with for over a decade appeared to have stopped sending annual summaries. At the time, Karen had mentioned something about institutions switching to electronic correspondence. I had accepted that. I accepted a great many things Karen said. Year 4 the gaps widened. Property tax notices, which arrive like clockwork every autumn, were simply absent. I could not find a single one. When I had asked Karen about taxes during that period, she told me everything was handled and current. I had no reason to disbelieve her. She was the organized daughter. The helpful one. Everyone said so. I thought about that reputation now, sitting at my kitchen table, and I wrote a single word on my notepad. Convenient. By the time I reached year 5 in my review, the pattern was no longer deniable. Correspondence from financial institutions had nearly stopped. Government mail had become rare. Notices that should have arrived annually were simply not there. And every single gap lined up with the years Karen had been managing my mail. I am not a dramatic person. I did not slam folders shut or push papers across the table. I sat quietly and continued writing dates on my notepad in 2 columns. What should have arrived and what I actually had. The second column was almost empty. I thought I had found the full shape of the problem. I was wrong. The mailbox forwarding paperwork was in a folder I had nearly set aside. When Karen first suggested the arrangement 7 years ago, she had brought the forms to me herself. She explained it simply. The post office would route certain correspondence to her address. She would sort it, remove anything unnecessary, and pass along what I needed. She made it sound like a filter. Like a kindness. I had signed the original form without significant concern. I remembered signing it. I remembered the pen she handed me and the kitchen table we were sitting at, and the cup of tea I had in front of me. What I did not remember was signing anything after that. Forwarding arrangements through the postal service are not permanent. They require renewal. They have expiration windows. After a set period, if no renewal is filed, the arrangement ends and mail returns to the original address. I had assumed the arrangement had quietly expired on its own years ago. I had never thought to check. I pulled the folder open and read through the paperwork slowly. The original form was there. My signature at the bottom, dated 7 years earlier. Behind it was a second form. A renewal. My name was typed in the appropriate fields. A signature appeared on the line. I looked at that signature for a long time. It did not look like mine. I set the paper down and picked up my notepad. I was not going to accuse anyone of anything based on my own impression of my own handwriting. I understood that documents require proper analysis. I understood that my instinct was not the same as evidence. But I kept looking at the signature. There is a particular quality to the way I write the letter C. A specific loop I have had since elementary school. It appears on every document I have ever signed. Insurance forms. School records. My husband's estate paperwork. The C on the renewal form was different. Close but different. I turned to the next page behind it. There was a third form. Another renewal. Same typed name. Same mismatched signature. I set it beside the second form and compared them side by side. Then I opened my original form and compared all three. The forwarding arrangement that was supposed to have been a temporary convenience had been renewed more than once. Across multiple years. With signatures I did not write. And every renewal had kept Karen's address as the destination for my mail. The arrangement had never been allowed to expire. Someone had made sure of that. I did not call Karen. That decision came quietly the way most important decisions do. Not with drama. Not with a moment of resolve. I simply looked at those 3 forwarding forms spread across my kitchen table and understood that calling Karen was no longer the appropriate next step. If those signatures were not mine, then Karen had filed renewals without my knowledge. And if she had done that, then she already knew what I was looking at. I needed someone who did not have a reason to protect her. The following morning I contacted the Postal Service directly. I explained that I had questions about a mail forwarding arrangement connected to my address. I had the original form number. I had my identification. I was polite and methodical because that is how I approach things that matter. The representative I spoke with pulled up the records while I was on the line. The forwarding arrangement had remained continuously active. Not for the original agreed period. Not for a year or two. For the entire duration of the 7 years since Karen had first suggested it. There had been multiple renewals filed across that time. Each one extending the arrangement before the previous one expired. The representative read me the filing dates in a flat, routine voice. He had no idea what those dates meant to me. He was simply reading from a screen. I wrote every date on my notepad without commenting. When I thanked him and ended the call, I sat with the notepad for a long moment. 7 years. The arrangement had never lapsed for a single day. I found Thomas Grant through a referral from a woman I had known since my working years. She had used him for an estate matter and described him as someone who dealt exclusively in documentation. No theatrics. No assumptions. Records and facts in that order. That was exactly what I needed. I met with him 4 days after finding the forwarding forms. I brought the folders, the forwarding paperwork, the notepad with my timeline, and the foreclosure notice that had started everything. Thomas listened without interrupting. He looked at each document I placed in front of him without touching them until I had finished speaking. Then he asked 3 questions. He asked how long the arrangement had been active. I told him 7 years. He asked whether I had authorized every renewal. I told him I had authorized the first one. He asked whether I had kept records from before the arrangement began. I told him I had kept everything. He nodded slowly, picked up a pen, began writing. He told me he wanted to request correspondence logs from every financial institution connected to my name and property. He also wanted official records from the Postal Service regarding every renewal filing. He said to give him 2 weeks. I told him to take whatever time he needed. I thought the postal records would be the worst of it. I was wrong. The records came back in stages over the following 10 days. The Postal Service responded first. The official correspondence log confirmed everything the phone representative had told me, but now I had it in writing. Every renewal date. Every extension. A continuous, unbroken chain of forwarding activity stretching across 7 years. Receipt number 1. Thomas had it flagged and filed before I finished reading it. The change of address documentation came next. Formal records showing each individual renewal submission, the filing method, and the address designated to receive the redirected mail. Karen's address. Every time. Receipt number 2. I looked at that address printed on official postal documentation and felt something settle in my chest. Not anger. Certainty. There is a difference. Anger is emotion. Certainty is information. And information was what I needed. The bank correspondence logs arrived on a Thursday afternoon. Thomas called me within an hour of receiving them. He read through the summary carefully before speaking, and when he did, his voice carried the particular flatness of someone presenting facts they find significant. He told me that multiple institutions had been sending correspondence to an address other than mine for years. Account statements, annual notices, periodic disclosures, all of it routed elsewhere. Receipt number 3. I asked him how many institutions. He told me the number. I wrote it down. The figure was not small. I had believed Karen was helping me manage correspondence from 1 or 2 sources. The logs showed something considerably broader. Categories of financial mail I had not even known to look for had been redirected so consistently and for so long that the institutions themselves appeared to have updated their records accordingly. My name was on the accounts. My address was not. I thought that was the extent of what the bank logs would show us. Then Thomas paused. He said one of the bank representatives had mentioned something during the records request that he had not been expecting. A large account connected to my property had been receiving statements at a separate address for several years. He said he had asked the representative to clarify. The representative confirmed it. Thomas told me the account number. I did not recognize it. He told me the account was connected to my property address. I had never opened it. Neither of us spoke for a moment. Then Thomas said quietly that he needed to find out exactly what that account was. Because as of that phone call, neither of us knew it existed. Thomas gave me one instruction before our call ended that Thursday. He said, "Do not change anything. No confrontations. No questions. No shifts in behavior that Karen might notice." He explained it plainly. The moment Karen understood that an investigation had begun, documents could be moved. Records could be altered. Evidence that currently existed in a recoverable form might not exist in that form for long. He had seen it happen before. I told him I understood. And I did understand. Not just logically. I understood it in the specific way that a person understands something when they have spent decades watching how people behave when they believe they are not being observed. Karen had been comfortable for 7 years. Comfortable people make mistakes. I intended to let her remain comfortable. The following Sunday, Karen came to dinner. She arrived late, which was normal for her. She set her bag on the chair by the door, which was also normal. She moved through my kitchen with the easy familiarity of someone who considered the space partly her own. I watched that familiarity with different eyes than I had the week before. I served dinner. I asked about her week. I listened to her answers. She mentioned the foreclosure notice once, briefly, near the end of the meal. She said she had made a few calls and it was being handled. Nothing to worry about. I thanked her. I wrote down exactly what she said when she left. The county records office responded to Thomas's formal request 8 days later. Property tax notices are public record. The county maintains documentation of every notice issued, the address it was sent to, and any updates to the mailing address on file. What came back was receipt number 4. For several consecutive years, the mailing address on file for my property taxes had been updated to reflect a different location than my home. Not a dramatic change. Not an obvious one. Just a quiet administrative update, filed through the appropriate channels, redirecting official county correspondence away from my front door. I had never submitted that update. Thomas flagged the filing dates. They corresponded almost exactly with the period when my property tax notices had stopped appearing in my records. The gaps were not gaps at all. They were redirections. I thought that finding was the clearest evidence we had. Then Thomas sent me receipt number 5. He had submitted formal records requests to 2 of the financial institutions identified in the correspondence logs. What came back were email records. Specifically, requests submitted through each institution's customer correspondence system asking for replacement copies of documents, annual statements, disclosure notices, account summaries. The requests were submitted by someone identifying themselves as acting on behalf of the account holder. The replacement documents were sent to an address that was not mine. The email records showed a consistent pattern across multiple years. Whenever a document appeared to have been delayed or returned, a replacement request followed within days. The replacements were rerouted before they could reach me. Nothing was left to chance. I read through those email records twice at Thomas's office, seated across from him at a long rectangular table covered in organized folders. The room was quiet except for the sound of paper. Thomas had built a physical timeline by that point. A long sheet of paper running the length of the table, marked with dates, document types, and routing destinations. Looking at it laid out that way, end to end, the pattern was impossible to misread. Every significant piece of financial correspondence connected to my name or property had been intercepted, redirected, or replaced across a span of years. Not occasionally. Systematically. I sat with that timeline for a long time. Thomas let me look without speaking, which I appreciated. When I was ready, I asked him whether he had identified the unknown account yet. He said he had been about to tell me. He set a new folder on the table and opened it to the first page. He had contacted the institution holding the account. He had submitted documentation establishing my identity and my connection to the property. He had requested disclosure of the account type and basic structure. The response had come in that morning. He read it to me directly without preamble because Thomas did not soften things with extra words. The account was not a savings account. It was not a checking account. It was not any kind of deposit account. It was a loan. A lending instrument secured against the equity in my property. Opened during the 5th year of the forwarding arrangement. I had not applied for it. I had not signed for it. I had not received a single statement from it at my address. For years, an account I did not know existed had been accumulating activity against a house I had spent 4 decades paying for. Thomas closed the folder. He did not say anything else. He did not need to. Thomas requested the full loan file on a Monday. By Wednesday, the institution had responded with a formal disclosure package. Thomas called me that afternoon and asked if I could come to his office the following morning. He did not tell me what was in the package over the phone. That told me something on its own. I arrived at 9 o'clock. The folder on Thomas's table was thicker than anything we had reviewed before. He had already been through it. I could tell by the small tabs of paper marking specific pages, the way he had organized sections with binder clips, the notes written in his careful handwriting along the margins of his legal pad. He did not begin with context or explanation. He opened the folder and showed me the balance. I looked at the number for a moment without speaking. Then I asked him to confirm the figure. He confirmed it. $430,000. Secured against my home. Against a property worth just under $1 million. I have managed household finances for most of my adult life. I understand what numbers mean. I understood precisely what that number meant. Someone had borrowed against my home. Borrowed heavily. And every payment obligation, every statement, every reminder and warning and collection notice connected to that debt had been routed away from me before it could arrive. I learned later that Karen had been carrying significant personal debt during this same period. Credit cards. Failed business obligations. Loans she could not service. I did not know any of that at the time. What I understood sitting across from Thomas that morning was that someone had accessed nearly $500,000 using my property as collateral. And I had never seen a single document connected to it. I sat with that for a moment. Then I told Thomas to continue. Receipt number 6 was the loan servicing file. It was substantial. Hundreds of pages documenting years of account activity. Statement cycles. Payment records. Payments made inconsistently in the first year before stopping entirely, triggering escalating notices, collection correspondence, and eventually default proceedings. Thomas walked me through the mailing address on record for every single document in that file. Not one of them listed my home address. Every statement, every notice, every warning letter the institution had generated across the life of that loan had been directed to the same alternate address. Karen's address. He had confirmed it against the postal records we already held. The match was exact. I thought about Karen sitting at her own kitchen table, opening envelopes addressed to my property, reading statements on a loan I did not know existed. Watching the balance and the missed payments and the escalating consequences accumulate month after month. And then driving to my house for Sunday dinner. Sitting across from me. Telling me everything was fine. I wrote 3 words on my notepad. She knew everything. Thomas set the servicing file aside and placed a thinner folder on top of it. The initial loan authorization documents. These were the papers that would have been generated when the loan was originally opened. The application. The approval paperwork. The closing documents establishing the terms and securing the loan against the property. The papers that would have required my signature. He opened the folder to the first tab page and turned it toward me. I looked at the authorization form. My name was printed in the appropriate fields. The property address was listed correctly. The date reflected the 5th year of the forwarding arrangement, exactly as Thomas had indicated when he first identified the account. I looked at the signature line. And I stopped. I have looked at my own signature thousands of times. On school records and insurance documents and bank forms and my husband's estate paperwork and every piece of administrative correspondence I have managed across a lifetime. The signature on that authorization form was not mine. It was close. It had clearly been constructed by someone who had studied my handwriting. The general shape was similar. The letter proportions were approximate. But the C at the beginning of my first name had the wrong loop. The L that opens my last name leaned at the wrong angle. The overall rhythm of the signature, the way the letters connect and the places where the pen lifts, was subtly but definitively different from anything I had ever written. I had suspected the forwarding renewal signatures were forged. This was something else. This was a financial instrument. A legally binding document securing hundreds of thousands of dollars against my home. With a signature that was not mine. I looked up at Thomas. He was watching me with the steady expression he carried through everything we reviewed together. Not sympathetic. Not alarmed. Focused. He said he had noticed the same thing when the file arrived. He said he had already marked it for formal handwriting analysis. Then he said there was something else. He turned to the second tab page in the folder. I looked at what he was pointing to, and I understood immediately why he had not mentioned it on the phone. The authorization form carried a notary seal, an official stamp certifying that the signature had been witnessed and verified by a licensed notary public. The notarization listed a date, a location, and a notary identification number. Thomas had already checked the date against records I had provided during our first meeting. On the date listed on that notary seal, I had been 3 states away attending my granddaughter's school event. There were photographs. There was a signed guest register. There were witnesses. I was not in this city on the day a notary claimed to have watched me sign my name. The signature was forged. The notarization was false. And that was not the worst part. The worst part was what the notary seal meant. A forged signature alone is fraud. A forged signature with a falsified notary certification is something more deliberate. It means someone had not simply imitated my handwriting. They had built official institutional cover around that imitation. They had anticipated scrutiny and prepared a document designed to survive it. This was not a moment of desperation. It was a plan. Thomas submitted the notary verification request the same afternoon we reviewed the authorization forms. The process was straightforward. Every licensed notary public maintains a record of the transactions they witness. Date, location, parties present, document type, identification verified. These records exist precisely because a notary seal is a legal certification. It carries weight in courtrooms and in property disputes and in fraud investigations, which meant it could also be checked. Thomas contacted the licensing board and submitted a formal inquiry tied to the identification number stamped on the loan authorization documents. While we waited, he turned to the signature comparison. Receipt number 7 was the full authorization form package. Thomas had requested every document from the loan file that carried my name or signature. The application, the approval consent, the closing agreement, the property authorization addendum. He laid them across the table side by side and placed my verified signature samples next to them. Documents I had signed in front of witnesses. Documents with independent confirmation of date and location. My husband's estate paperwork. A notarized affidavit from my working years. Bank signature cards from accounts I had opened in person. The difference was visible without expert analysis. Consistent across every loan document, the same small distortions appeared. The loop on the C. The angle of the L. The way the pen pressure shifted in the middle of my last name. Every signature on every loan document had been produced by the same hand. That hand was not mine. Thomas labeled each document, noted the discrepancies in writing, and set the package aside for the forensic examiner he had already contacted. I watched him work with the methodical patience of someone who had done this before and understood that precision now meant protection later. I thought the notary records would simply confirm what the signatures already showed us. They showed us considerably more than that. The licensing board response arrived within the week. Receipt number 8. Thomas called me before he sent the documents, which was unusual for him. He typically forwarded records without preamble. When he called, he said only that the notary records contained information I should review with him present. I drove to his office that afternoon. The notary identified on the loan authorization had produced their transaction log in response to the formal inquiry. The log listed every witnessing event recorded under that license number across the relevant period. The date listed on my loan authorization did not appear anywhere in that log. Not recorded as a different transaction. Not listed under a modified description. Simply absent. The notary had no record of ever witnessing a document connected to my name, my property, or the loan institution in question. Thomas placed the transaction log beside the loan authorization and pointed to the stamp. Same license number. Same notary seal. No corresponding record. Which meant one of two things. Either the notary had failed to log the transaction as required by law, or the seal had been applied to a document the notary never witnessed. Combined with my documented whereabouts on that date, the conclusion was not difficult to reach. The notary seal on that loan authorization was fraudulent. I sat across from Thomas and thought about the word that now applied to everything we had assembled. The word was forgery. Karen called me that Thursday evening. She called regularly. He always had. Part of the image she maintained required consistent contact, check-ins, the performance of attentiveness. I answered the way I always answered. Calmly. Normally. I asked about her week. I mentioned that I had been sorting through some old paperwork, which was true and unremarkable, and gave her nothing to react to. She talked for nearly 20 minutes. Near the end of the call, I mentioned that I had come across some old mail while going through boxes. Correspondence I barely remembered receiving. I said it in the tone of mild curiosity an older woman might use when describing something mildly puzzling. I said I was surprised how much paper accumulated over the years. Karen's response was immediate and easy. She said that was exactly why she had always tried to help manage things. She said some of that correspondence was probably unnecessary to begin with. Then she said something else. She said, I kept some of those letters because she would have worried. She caught herself within a breath and redirected the sentence, moving past it into something else. But the sentence was already finished. I kept some of those letters because she would have worried. She had not said you. She had not addressed me directly. She had spoken about me in the third person, the way people speak when they are recalling a conversation they had with someone else, or rehearsing a justification they had repeated to themselves so many times it came out automatically. I did not react. I let her finish the call. I said good night. I thanked her for checking in. Then I sat in my chair and looked at the small digital recorder on the table beside me. Thomas had advised me 2 weeks earlier that our state permitted single-party recording of telephone conversations. He had suggested I keep a recorder near the phone. He had told me that comfortable people make careless statements, and that careless statements made to someone they trusted were the most valuable kind. He had been right. I pressed stop. The following morning I drove to Thomas's office and placed the recorder on his table. He put on headphones and listened to the full call. I watched him. Halfway through he picked up his pen. Near the end he set it back down. When the recording finished he removed the headphones and looked at me across the table. He said that in 2 decades of practice, evidence fell into 2 categories. Evidence that showed what happened, and evidence that showed someone knew what they were doing. He said the recording was the second kind, because Karen had not slipped and admitted to a mistake. She had slipped and admitted to a decision. I kept some of those letters because she would have worried. Not an accident. Not an oversight. A choice. Repeated. Deliberate. Justified in her own mind by a logic she had been carrying for years. Thomas labeled the recording, noted the date, and added it to the file as receipt number 9. Then he looked at me and said we were ready to move to the next stage. Karen still believed she controlled the information. She had just handed us the most important piece of it. The hearing was scheduled for a Tuesday morning. A mandatory mediation and property proceeding, convened because the foreclosure process had triggered formal legal requirements that could not be resolved through phone calls or paperwork alone. All parties with an interest in the property were required to attend. Thomas had prepared for 6 weeks. I had been preparing for considerably longer, in the particular way that methodical people prepare. By saving everything. by dating every document, by never throwing away a piece of paper that might someday need to explain itself. The room was a conference facility attached to a legal services office. Long rectangular table. Chairs on both sides. A mediator at the head. Financial representatives from the lending institution on one side. Thomas and I on the other. Lauren had flown in the night before. She sat beside me and said very little. She had seen portions of the evidence file the previous evening, enough to understand the general shape of what had happened, not yet enough to understand its full scale. Karen arrived late. She walked in the way she always walked into rooms where she expected to be the most capable person present. Shoulders back. Expression composed. She set her bag down, greeted the mediator, and took her seat across from Thomas without looking directly at me. Her attorney sat beside her, a younger man who had clearly been given a limited version of events. Karen looked confident. That was important. Confidence in a proceeding like this leads people to volunteer information, to fill silences, to explain themselves before explanations are requested. Thomas had told me to let her be comfortable for as long as possible. I folded my hands on the table and said nothing. The mediator opened the proceeding and invited Thomas to present the basis for contesting the foreclosure action. Thomas stood. He did not use dramatic language. He did not characterize Karen's behavior or make accusations or describe what he believed had happened. He simply stated that he would be presenting a chronological record of correspondence and documentation relevant to the property, and that he would allow the documents to establish the facts. He placed the first document on the table. The original mail forwarding form. My signature. Dated 7 years earlier. He described it in one sentence and moved on. The second document. The first renewal. The signature that did not match mine. One sentence. Moving on. Third document. The second renewal. Same mismatched signature. Karen's attorney leaned toward her and said something quietly. Karen shook her head slightly. Her expression remained composed. She still believed this was manageable. Thomas moved through the mail forwarding timeline methodically. Postal Service records. Filing dates. The continuous, unbroken chain of renewals extending across 7 years. He placed each document on the table in sequence and stated its contents in plain language. Karen interrupted once, during the third document set. She said the forwarding arrangement had been set up at her mother's request and that she had simply helped maintain it because her mother found paperwork confusing. Thomas acknowledged the statement, set it aside, and continued. He placed the bank correspondence logs on the table. The systematic redirection of financial statements across multiple institutions, across multiple years, all routed to the same alternate address. Karen's address. He read the address aloud from the official postal record. Karen said that was also done for convenience. That she had been sorting her mother's mail as a service. That there was nothing unusual about a daughter helping an elderly parent manage correspondence. Lauren made a small sound beside me. Not a word. Just a breath. I kept my hands folded on the table. Thomas introduced the loan. He placed the initial disclosure on the table and stated the balance. $430,000. The number landed differently in a room full of people than it had in Thomas's office. The mediator's expression shifted. The financial representatives exchanged a look. Karen's attorney sat up straighter. Thomas presented the loan servicing file. The years of statements. The escalating collection notices. The default correspondence. Every document routed to Karen's address. Never to mine. He presented the authorization forms. The signatures that did not match my verified samples. The forensic examiner's written analysis, confirming the discrepancy across all documents. Karen said the signatures were valid. She said I had been present at signing. She said I sometimes signed documents differently depending on the pen and the surface and whether I was tired. Thomas placed my verified signature samples beside the loan documents and said nothing. The room looked at both sets of signatures. Karen's attorney stopped writing on his notepad. Thomas played the recording. He set a small device on the table, stated the date and the nature of the call, and pressed play. Karen's voice filled the room. Relaxed. Familiar. The voice of someone who believed she was having a private conversation. I kept some of those letters because she would have worried. Thomas stopped the recording. Karen said the statement had been taken out of context. She said she meant something different. She said anyone who knew her understood she had always acted in her mother's best interest. Lauren looked at her sister from across the table. She did not say anything. He did not need to. Karen kept talking. She had an explanation for every document. A justification for every redirect. A reason for every gap. She spoke with the fluency of someone who had been rehearsing alternative narratives for a very long time. She said she had done nothing wrong. He said that clearly. Twice. Then Thomas placed a final folder on the table and opened it to the first page. County records. He had not mentioned these before. They were not part of the sequence Karen had been preparing to address. I watched her eyes move to the top of the document. I watched her read the first line. And for the first time since she had walked into that room with her shoulders back and her expression composed, Karen's face changed. The county records document was 4 pages long. Thomas did not summarize it. He did not describe it in advance or frame it with context. He simply placed it on the table, opened to the first page, and gave the room time to read. Receipt number 10. What the document showed was this. Against my property, the house I had owned for over 40 years, the house whose mortgage I had celebrated paying off, the house that represented every financial decision my husband and I had made responsibly across a lifetime together, there were liens. Multiple liens. Filed across different periods. Connected to different instruments. Each one a legal claim against the property's value by a creditor with an outstanding interest. Not one of them had ever been disclosed to me. Not one corresponding notice had reached my address. Karen had known about every single one. The room was quiet in a way that rooms do not usually become quiet. Not the quiet of people waiting for someone to speak. The quiet of people absorbing something that has just rearranged their understanding of events they believed they already understood. The mediator looked at the document, then at Thomas, then at Karen. The financial representatives were writing. Lauren, beside me, had stopped moving entirely. Karen's attorney placed his pen flat on the table. Karen herself had not spoken since Thomas opened the folder. Thomas presented the master timeline. It was the document he had spent 6 weeks building. A complete sequential record, beginning with the original forwarding arrangement 7 years earlier and ending with the foreclosure notice that had been taped to my front door. Every redirected statement. Every intercepted notice. Every collection letter. Every warning. Every escalating communication the loan institution had generated as the debt grew and the payments stopped. Every single item had passed through Karen's address before it could reach mine. Thomas walked through the timeline in sections, stating dates and document types in the same steady voice he had used for everything else. As he moved through the final years, the entries became more frequent. Warning notices. Formal demands. Pre-foreclosure notifications. Each one arriving at Karen's address. Each one concealed. The foreclosure that had appeared on my door had not been a sudden event. It had been the end of a long sequence that Karen had watched develop month by month, document by document, and chosen to manage in silence rather than disclose. Thomas reached the end of the timeline and set it down. He said he had nothing further to present. Karen's attorney requested a brief recess. Karen did not look at me during the recess. She spoke to her attorney in a voice too low to carry across the room. At one point she pressed her fingers against the table in front of her. A flat, deliberate pressure, the gesture of someone working to maintain composure through physical contact with a stable surface. When the proceeding resumed, her attorney spoke on her behalf. His statement was careful and brief. He said his client's position was that her actions had been motivated by a desire to protect her mother from financial stress. He said the matter of the loan authorization would require further review. He said his client wished to resolve the matter cooperatively. Karen said nothing. The woman who had walked into that room late with her shoulders back and her explanation already prepared had nothing left to say. Every narrative she had constructed across 7 years had met a document that outlasted it. Karen's attorney placed his pen flat on the table and did not pick it up again. Lauren called me that evening from her hotel room. She already knew the broad shape of what had happened. She had reviewed the evidence file the night before the hearing. What she did not yet know were the pieces that had come before it. The night in the filing cabinet. The forwarding forms with the wrong signatures. The conversation with the postal service. The quiet weeks of investigation while Karen sat at my dinner table telling me not to worry. She asked about those pieces specifically. I told her. She listened without interrupting, which was not like her. When I finished, she was quiet for a moment. Then she said she needed some time. I told her to take whatever she needed. 3 days later, she sent Karen a message. I did not ask to read it. Lauren told me only that it was final. That she had said what she needed to say. That she did not intend to revisit the decision. She has not spoken to Karen since. The legal consequences unfolded across the following months. Civil proceedings were initiated. The fraudulent authorization documents were referred for further investigation. The notary discrepancy triggered a separate inquiry through the licensing board. Multiple agencies requested the evidence file Thomas had assembled. The liens against the property were challenged and addressed through the civil process. The loan itself became the subject of a formal dispute given the documented evidence of unauthorized origination. My home was never transferred. My home was never lost. Karen gained nothing she had spent 7 years maneuvering toward. She lost her legal standing in relation to the property. She lost her role in my affairs. She lost the access she had cultivated carefully across an entire decade of Sunday dinners and phone calls and the patient performance of devotion. She lost Lauren permanently. She lost the trust of extended family members who had always described her as the responsible one. Who had always said how lucky I was to have a daughter so willing to help. What they eventually understood was that the willingness had never been about helping. It had been about positioning. Several months after the hearing, on an ordinary morning, I walked to my mailbox. No reason in particular. No specific document I was expecting. Nothing urgent or significant on the calendar. I opened the small metal door and looked inside. A bank statement. Addressed to me at my address. In an envelope that had traveled directly from the institution to my home without passing through anyone else's hands. I took it out and held it. It was an unremarkable piece of mail. The kind that arrives every month and requires 5 minutes to review and file. I stood at the end of my driveway for a moment before walking back inside. There is a particular quality to ordinary things that have been taken away and returned. They do not feel ordinary anymore. They feel like what they always should have been. Karen spent 7 years building a structure of control around a single belief. That she was smarter than me. That my age made me manageable. That the information she held gave her permanent advantage. That the house she had decided was already hers was simply waiting for her to complete the claim. She was wrong about all of it. She spent 7 years hiding paper trails. The paper trails spent 7 years waiting. And when the time came, they were still exactly where she had left them. So was I.